5-6. Okay, we are back on the record. This is technically our third time on the record in this matter at the preliminary stage. And that was to allow all of the attorneys to have a time to look at the petition and to properly prepare for the preliminary hearing and a review of the emergency removal order that was issued. I have the names of our participants, please, beginning with our guardian ad litem.
Good afternoon, Your Honor. Ariel Berger here as the lawyer guardian ad litem for the minor children.
Good afternoon, Your Honor. Nastasia Thomas, appearing on behalf of the department and also appearing as co-counsel, Mr. Amadeo.
Good afternoon, Your Honor. William Amadeo, P76194 for the department. Consent to this hearing via Zoom. And our workers, Nikki Jones. Nikki, please state your name for Judge Sala.
Nikki Jones, Your Honor, CPS investigator.
Thank you. Ms. Jones is the only one in the courtroom with me today, looks like, which is all right. Everybody's signal sounds pretty good so far. Let's go to private counsel.
I'm sorry?
Yep, if you could
For me.
introduce yourself, client,
Oh,
yes.
Yeah, this is Alex Lizahub. I'm the attorney for the respondent, whom also appears by Zoom, and I have to apologize to Your Honor. I had been on a different Zoom address that I wrote in my book, but I thought it was for this case. So I apologize, it's my fault. I didn't put the right number in, but it was not intentional, believe me. I was waiting in some other courtroom for you, so it's my fault, Judge, sorry.
That's all right, welcome. If you could either introduce your client or ask him to introduce himself, please.
Matt, could you please state your name for the record?
Yes, Matthew Virgil Higgins Jr.
Yeah. Okay, Mr. Lizahub, do you have a copy of the petition at this point, and have you had a chance to go over that with your client?
Yes, Your Honor, we waived the formal reading of the petition.
Thank you so much. Do you know if your client can confirm whether or not he has any Native American heritage, is a member, or thinks that he or any of the children would be eligible for membership in any Native American tribe or band?
No, he is not. He is not a member of any. He's not a member of any Indian tribe. That's the answer. The answer is no.
And does he have anything in his family background that would make him think, if you know, whether or not he or any of the children could be eligible for enrollment in a tribe or band?
Based on my interview, the answer is no.
Thank you. All right. Are there any other cases that concern the same minors in this petition?
The only other case is a case out of Wayne County Circuit Court in which there was a parenting time order, but the children were placed with the ex-wife, and in that case there was an ex parte order entered to suspend all parenting time. I did receive a copy of that. If you want to, Judge, I can give you the case number for that other case if you need it.
Let me look. I'm hoping I already have that.
I've got
I
it
don't.
here. Okay, well let me give it to you, Your Honor.
Go ahead.
It's Wayne County Circuit Court, that's Third Circuit, 12-100-121-DM.
Okay, and does that concern all 4 children?
Yes,
Thank you.
the parties did have a 5th child, but that child's adult.
Thank you. All right. Well, at a preliminary hearing, your client has the opportunity to admit or deny all of the allegations contained in the petition. And of course, he also has the right to ask for a jury trial or bench trial, wherein the trial would be conducted by the department, and they would have the burden to show by a preponderance of the evidence that the allegations in the petition are true and cause, concern over the welfare of the children under the particular statutes that have been cited herein. Do you know how your client would like to proceed?
We are demanding a jury trial and we deny as untrue any impropriety.
Thank you. All right, so we can look for some dates on that point. Is your client inclined to contest the removal order?
At this time, no, Your Honor,
All right.
but I don't want to waive any future ability to do that.
Well, at each review hearing, we would look at that, including any pretrial review hearings that would happen ahead of the trial dates that we'll be looking at. There is let me look at the dates that I've got available here, and then we'll, in the meantime, let's go over to counsel. Who will be taking point on this, counselors?
Your Honor, today, Mr. Amadeo is going to be covering. I have to jump off for a hearing in Monroe. Mr. Amadeo will also be point on trial as trial lead.
So, Mr. Amadeo, what if anything would you like covered as part of today's preliminary hearing?
Your Honor, I'd like to call Nikki Jones to the stand for the preliminary hearing.
All right, Ms. Jones, you can stay right where you are for today.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very good. May I proceed, Mr. Amadeo?
Thank you. Nikki, can you hear me okay?
Yes, sir, I can.
Okay, please state and spell your full name for the record.
Nikki Jones, Nikkijones.
What is your role in this matter?
I am the CPS investigator assigned to the case.
And did you draft the petition for the court today?
Yes, I did.
Would it be fair to say you know more about this case than anybody else at this juncture?
I believe so.
Who is Matthew Higgins?
Matthew Higgins is the father of the 4 minor children aforementioned in the petition.
Would he be deemed the respondent father in this matter?
Yes, he is.
As the investigator in this matter, how did you learn about the allegations contained in the petition?
I received a referral from our centralized intake regarding the allegations.
Based on your review thus far, do you believe there's substantial risk of harm to the child's life, physical health, or well-being to remain in the care and custody of Mr. Higgins?
Yes, I do.
We'll get into some questions, but could you briefly explain why you formed that opinion?
Based on the allegations in the initial complaint that were received, and then follow-up interviews at the Child Advocacy Center with one of the minor children, I do feel like the removal from his home is appropriate at this time, due to the seriousness, I guess, of the allegations.
What reasonable efforts were made to prevent removal?
At this time, due to the nature of the allegations, no reasonable efforts were made at this time. The allegations do surround sexual abuse. We initiated some safety planning, which Mr. Higgins was aware of when we placed him with a non-respondent parent.
Okay, let's get into that. Who is proposed placement for the child?
The child's biological mother, for the children's biological mother, Leanne Elizabeth Higgins.
And do you believe that Ms. Higgins is the least restrictive placement to ensure safety?
I do at this time.
Okay, can you explain for the record, what is a Category 1 complaint?
Category 1 complaint is one of the complaints that have been substantiated due to one of the major offenses, one of those including sexual abuse.
So is this a Category 1 complaint?
Yes, sir.
And what is the actual complaint?
I'm gonna object to hearsay, Judge.
Do I read it?
Mr. Amadeo, would you like to address that?
I'm asking what's in the complaint in the investigation. I didn't ask for an out-of-court statement to prove the truth of the matter asserted. I don't
That's
see
the
that's
testimony,
hearsay
Judge.
at all.
The complaint speaks for itself.
Well, maybe you haven't done preliminary hearings, sir, but you have to address the complaint for the record.
There is also the fact that at a preliminary hearing, Mr. Lizahu hearsay is admissible. It would not be the case at the adjudication trial itself, but for purposes of today's hearing, hearsay is admissible.
So, Ms. Jones, what is the complaint?
Are you asking for a summary or a direct reading of the complaint?
No, a summary's fine.
Okay, so to summarize the complaint, the allegations were that Madison was being sexually assaulted by her father, Matthew Higgins. And then it just talks about that she didn't like those behaviors and some of the behaviors that he was doing as a result of some of her allegations. So would you like me to go into those or not?
I'll ask you some questions about that. That's
Okay.
As part of the complaint, is there allegations that Mr. Higgins, and let's just use the initials for the child because we're on YouTube, MH. Is there allegations that Mr. Higgins makes her
I'm
shower?
gonna
and sleep with
object to
him?
hearsay, leading, excuse me.
Okay, Your Honor, if I may respond, I think you just ruled that hearsay is allowed at the preliminary hearing. And I'm actually asking an open-ended question, which is not leading.
It's leading.
Actually, it's not.
Okay, on the issue of leading questions, that's addressed under Rule 611. It does indicate under Section D, leading questions should not be used on the direct examination of witness except as may be necessary to develop the witness testimony. So I'm not sure that was an unorthodox moment for purposes of looking at that particular question. So I'm going to overrule the objection on that. May continue.
So, Ms. Jones, again, are there allegations that Mr. Higgins makes his daughter take a shower with him?
Yes.
Are there any allegations about making his daughter sleep with him?
Yes.
Are there any allegations about him touching her in a sexual manner?
Objection leading, Judge. I mean, I can understand your ruling to develop the witness's testimony, but this is clearly directing the witness to testify as requested.
If I may respond, Your Honor, actually, if I would have said, isn't it true that his client touched his daughter for sexual purposes, that would be leading. When I'm asking, is there an allegation of such? That's an open-ended question, which even in a criminal court of law, as I know brother counsel's familiar with, would be allowed.
Thank you. Yes, I would agree. The objection is overruled. You may continue.
Ms. Jones, do we have any knowledge if penetration has occurred in the preliminary exam?
In the initial complaint, there was not knowledge. However, in a subsequent interview, we did obtain additional information regarding penetration.
Was MH
Yeah. Microphone a little closer to you.
Sorry.
was MH, the victim in this matter, subjected to a forensic interview?
Yes, she was.
Who conducted that interview?
The Lenawee County Child Advocacy Center.
Were there any disclosures made at that interview?
Yes, there were.
Okay, can you explain what was disclosed per your investigation?
MH did disclose that she was required to sleep in her father's bed, shower with her father, and her father also stuck 2 fingers in her vagina.
Do we have any idea when this started?
MH disclosed that some of this type behavior started when the children were placed with him approximately 6 years ago.
Okay, do we know where this occurred?
MH had disclosed during her child advocacy interview that it started, the family was reportedly residing in some type of trailer at the time.
Do you know where the trailer was located?
It would have been in Wayne County.
Did anything ever occur in Onstead?
Yes.
Okay, can you tell the court what happened in Onstead?
in Onstead, in the area of Lenawee County, some of those same exact allegations did occur. She was sleeping in her father's bed. She disclosed that she was showering with him, and he was also penetrating her vaginal area.
So would Lenawee County be appropriate for the jurisdiction here?
Yes, it would.
What else does the report indicate, if you recall?
The initial complaint or the interview?
Either or, open-ended.
Your Honor,
The initial,
Your Honor, I object pursuant to, I believe, 613. I am entitled to receive a copy of the report in question regarding the Lenawee County Child Advocacy Center forensic interview.
Your Honor, if I may address that, he will be entitled to such a report, but that's not due at the preliminary hearing. The whole point of preliminary hearings is to see if the elements are meant to proceed. Certainly, he'll get any discovery he's entitled to, but it's not really relevant here. But if it makes the court, if it pleases the court and in the guise of judicial economy, I could just move on.
However you'd like to proceed, Mr. Amadeo. It is true that discovery is automatic in these particular cases, no later than 21 days before the trial. 613 relates to prior statements of witnesses. So I'm not sure that one exactly applies to this particular objection. As it relates to the document itself, I'm sure that will be produced at a later date. I don't have that either. If it's any comfort to you, Mr. Zaha. Sorry.
Judge, I think those reports generally take several weeks, if not months, to prepare and circulate.
Yeah, and just for the record, for clarity's sake, to build the record, anything needed from respondents counsel, he could contact me directly and I will personally deliver it to him. So there's no issues with discovering this matter, Judge.
Well, Judge, I mean, the problem is you've got a witness who's not testifying from personal knowledge, referring to a report that I don't have a copy of. I don't know that that's proper. Now, how could I cross-examine the witness on that?
If I may address, Your Honor.
Go ahead.
It's very clear at the preliminary stage that respondents counsel can address with anything testimonial based. This is nothing more than testimonial evidence to see, and we are grading this matter if an element has been met. We are not at the trial phase. We are not in a full-blown evidentiary hearing. I'm sure we'll get there. With that being stated, I can move on and limit the questions, but all we're doing right now is building a record from the investigation phase. There is absolutely zero prejudice to the respondent or his attorney at this juncture, or will there be throughout these proceedings.
Well, Your Honor, I mean, it's a pretty serious allegations, and my client's constitutional rights are at issue. And now the witness is referring to a report which is really third hand at the hearsay now upon hearsay. And she's just testifying from the report. She's not the author of the report. So I do find that objectionable, and I don't believe she's able to do that.
Your Honor, I don't know if
Okay, hang on. The objections go to clearly the weight of the testimony rather than as it relates to admissibility, because again, the Michigan rules of evidence do not apply other than those with respect to privileges, except to the extent that they're abrogated by MCL 722.631. That provision is found in Michigan Court Rule 3.965, subsection B12. So rest assured, I clearly understand that the weight of this particular bit of information is offset by the level of hearsay that we're dealing with here today, but it is technically admissible. Mr. Amadeo.
Thank you. Move on to this, Ms. Jones. Is there a criminal investigation going on for Mr. Higgins?
yes, there is an ongoing criminal investigation.
Who is investigating? Do you know what agency?
Cambridge Township Police Department.
I'm going to object to relevancy, Your Honor.
Your Honor, if I may, a criminal prosecution, as brother counsel knows from Wayne and Oakland County, actually carries a greater burden. And if there's a companion case where there would be probable cause for a criminal prosecution, I would certainly meet my burden today. So it's beyond relevant that his client may be charged with a CSC as well to termination of parental rights?
Excuse me, Your
I
Honor.
need.
I'm
Mr.
having a
Higgins,
hard time. I'm having a hard time hearing.
well, then I suggest you discover a different device or make sure that the volume is up all the way on your end, because there's nothing I can do about your volume levels.
Okay, I have it volume all the way up. I was just stating
That is something you'll have to make sure you take care of at the next hearing, or just appear personally. That's always available to you.
Thank you, Judge.
All right, Mr. Lizahoop, any further argument on your objection? Or are you ready for a ruling?
I'm ready for your ruling, Your Honor.
Thank you. The court does find it relevant for purposes of determining whether or not to authorize the petition or to allow the petition to continue authorized as it has been authorized on an ex parte basis. So for those reasons, the objection is overruled.
Thank you, Your Honor.
And Ms. Jones, just going back to something, the CAC interview, did you actually witness that or not?
Yes, I was in attendance during the CAC interview.
Thank you. Does Mr. Higgins have any prior CPS history?
Yes, he does.
Can you explain to the court what that would be?
I'm gonna object to relevance, Your Honor.
Oh my God, Your Honor, if he has previous CPS history and there's a CPS allegation, I'm not sure how that would be unrelevant under any stretch of the imagination.
If I could respond, Your Honor, it would be relevant if it was a criminal sexual conduct related allegation, but that's not, to my knowledge, nothing in that manner. So I don't believe it's relevant.
And if I could respond to that, Your Honor, I'm not sure if brother counsel actually read his previous CPS history, but I believe the term perpetrator was utilized in the previous, so he was alleged to be a perpetrator once and alleged to be a perpetrator here. I don't know how there's not causation between those two that would not be relevant for our court to grade this situation.
Well, Judge, first off, I don't appreciate that the brother counsel is claiming I didn't read the materials. I did read the materials and I am familiar with the case. I am familiar with the prior matter trying to terminate the parental rights of the mother. None of that's been brought up, and anything to do, and I'm familiar with that history, alleged perpetrator, but that's nothing to do with sexual contact or allegations of sexual abuse of any kind with my client. So I don't see the relevance.
Well, Mr. Amadeo, in this case, there have been no reasonable efforts to prevent removal, which I would assume would be the reason we would want to know about prior CPS investigations, unless, of course, they are allegations similar to what we have here today. So can you clarify for me, would these allegations be allegations of any kind of violation in the criminal sexual conduct?
They're not, the prior allegations, Your Honor, are not CSC allegations whatsoever, but they are deemed category 2, where Mr. Higgins was deemed to be a perpetrator. I do think there's a correlation, but I also feel I don't need to waste the court's time with this particular issue, so I could just move on, Judge.
All right, thank you then. Go ahead.
Ms. Jones, are you familiar with statutory grounds for jurisdiction?
Yes.
Are they present in this case?
Yes, they are.
Are you familiar with the best interest factors used by the Michigan court rules?
Yes, I am.
Were those best interest factors reviewed prior to filing this petition?
Yes, they were.
As to the child's need for permanence and stability, where do you stand on those issues?
I do feel like the children are in need of permanency and stability. At this point, oh, go ahead.
Is there a bond between the
Children and their father?
Yes.
Yes, there is.
Based on your investigation, does Mr. Higgins have parenting ability at the current time?
What do you mean by parenting ability?
Has his ability to parent been compromised in any way?
I'm sorry, I didn't hear that question, sir. Could you repeat that, please?
Has Mr. Higgins' ability to parent been compromised in any manner?
I do believe his ability to parent has been compromised based on the seriousness and the gravity of these allegations.
Is the child in a relative placement?
Yes, they are.
Are minor siblings involved and are they placed together?
Yes, they are involved, and yes, they are all placed together.
Do the children have a relationship with extended relatives?
Yes, they do.
Do we know what the minor victim MH's wishes are right now based on your investigation?
I do. In speaking with MH directly, she does wish to reside in the home of her mother.
As for relief, what would you think, or what would you like to recommend to Judge Sala as for placement?
At this juncture, we would like the children to remain in the care and custody of their mother.
Is there anything else you would like to add based upon
Wait a
that?
minute, I'm sorry, Your Honor, that is an open-ended question that can't even. I'm gonna object to it as overly vague.
I'm sorry, is the objection?
Anything else you'd like to add to what?
Okay, I'll move on if that makes you happy.
Makes me happy, thank you,
Great, that one make you happy, sir.
thank you.
Do you want Mr. Higgins to have parenting time, Miss Jones?
At this point, we are recommending no parenting time with Mr. Higgins.
All right. If the court were to authorize this petition and the relief requested, what is the recommendation for parenting time? Is it to be suspended, or what do you feel is the best move there?
I'm gonna object to leading.
I'll rephrase. If the court were to authorize this petition, what is your recommendation for parenting time?
Our recommendation is the continued suspension of parenting time, which would be in alignment with the Wayne County front of the court order at this time.
Your Honor, I believe there's been a report and some supplemental documents presented to the court. I asked they be admitted. I have no further questions for this witness at this time.
Okay, could
Your
you
Honor,
articulate which particular documents you're referring to?
Believe a court report's been completed for today.
I think the only thing that I have seen come through is a copy of that custody order.
You do have a copy of the petition, correct, Your Honor?
Yes.
I would just ask that be admitted.
well, it's not necessary to admit a court pleading, it's already in the file, Judge, so I don't have an objection to that because the file is what the file is, so it doesn't have to move to admit, in my humble opinion, but Your Honor, of course, the court will decide that motion.
Hey, Mr. Lizahoop, do you have an objection to the court having a copy of the custody order?
No, Your Honor, absolutely not.
Ms. Berger?
No objection, Your Honor.
Thank you, then. It will become part of our court file. Questions for this witness, Mr. Lizahoop?
Thank you very much, Your Honor. First question, who was the forensic person whom conducted the Lenawee County Child Advocacy Center interview?
Janice Stiddens,
Could you please spell the last name for me, please?
Stiddons.
Okay. And what did you do to determine whether or not the mother was a suitable placement for the minor children?
We had a review of her CPS history, which we know that there is substantial CPS history, criminal history clearances, the central registry clearances, and we had Wayne County that visited the home on multiple occasions.
When you testified now that a review of her CPS history was extensive, was she accused of being a perpetrator, which was that perpetrator of an unsafe and unstable environment for children?
Yes, she was.
Okay, and furthermore, in fact, the allegations involved striking the children and beating them. Is that correct?
Judge, I'm going to object. If Mr. Lizahoop would like to strictly adhere to the rules of evidence and the rules of the court, then I would state that this is a leading question.
I can lead, Your Honor, can I respond? I can ask leading questions on cross. And number two, the rules of evidence are relaxed. And number three, this is a very important matter to the court since it's directly relevant to placement of the children and and one of the steps in attempting to terminate my client's constitutional parental rights. So I think it's very relevant.
Yes, Your Honor, I'm sorry. I thought that Mr. Who called Nikki Jones as a witness, not on cross.
Thank you. All right, the objection is overruled. You may continue.
Okay. Okay, so is it true that she was actually a respondent in a court's attempt to terminate her parental rights of the minor children?
I do not recall reviewing a termination. I reviewed a removal from her in placement with the father.
Did you review all the CPS contacts that Ms. Higgins had regarding the minor children in this case in which she was alleged that she was a danger to the children?
I did review her case history in which she was alleged to be a danger to the children.
What do you recall from the case history as to her being a danger to the children that you read?
There were multiple instances in which were classified improper supervision, where she either left the children alone or she left one of the older children to care for the triplets. There were some allegations in which she physically abused at least one of the older children. And there was some suspicion at some point of drug abuse, but I don't believe those were ever substantiated.
There was allegation too that she would give some substance to the children to make them sleep. Correct?
There was an allegation. That is correct. That was an allegation.
Okay. And she actually has a rather extensive history, a multi-year history regarding abuse of the children. Fair statement?
Objection. Counsel is testifying.
I'm sorry?
Counsel is testifying. I made an objection.
Judge, I made a question. No problem.
It is cross-examination. I'm gonna overrule the objection. Next question.
In fact, there was a long period of time where Ms. Higgins was not allowed to see the children unless she was supervised. Is that true?
There was a period of time in which she was required to have supervised parenting time.
How many years of contact with the CPS did Ms. Higgins have? Relative allegations against her only.
Judge, I'm going to object. I don't believe mother is a respondent in this case, so I'm not sure how her past history is relevant.
Your Honor, past history is relevant because the issue is whether or not the children are placed safely in their new environment, and it's very relevant.
So, Mr. Lizahoub, do you intend to present this in support of an argument that the children should be in foster care rather than placed with a parent pending further proceedings?
Potentially, Your Honor, but I'm just trying to build a record today.
I'm going to sustain the objection. The mother is not a respondent parent in this particular case. So I don't think we need to go into anything other than what the risks would be and what Ms. Jones has investigated those risks to be and whether or not they've been eliminated, which I would imagine there is some information on that point, given the fact that they've been placed with their mother.
Okay, so other than reading the allegations, the CPS allegations against mom, what else did you do to determine the mother was a suitable placement for the minor children?
I had a conversation with the mother as well, like I said, along with reviewing case history. And we determined that at this point, Wayne County had ordered her to have unsupervised parenting time with her kids, so she's no longer supervised. She hasn't had contact with CPS in multiple years, and she did have an appropriate living arrangement for the children.
Okay, when you say multiple years, what period of time are you talking about?
6+ years.
And are you aware of the acrimonious relationship between dad and mom? Dad meaning the respondent, my client, and Ms. Higgins, the ex-wife. Are you aware, let me restate the question. Are you aware that there is a very difficult situation between the two of them as it relates to the children?
Well, in interviews with both parents, both Matthew and Leanne, they did indicate historically there have been some issues with that relationship. However, both indicated separately within the last 2 years that they've both been getting along great and fine, and there have been no issues within 2 years.
Did you visit the home of Ms. Higgins?
I did not. So since they're not an adjoining county, Wayne County Department of Health and Human Services visited the home.
All right, was there some kind of report or any other written in documentation which reflects the living conditions of the children? Do they have separate bedrooms, adequate food, that kind of thing?
There would be a separate, it's not necessarily a report, it's just a narrative of what they found during that home visit, but yes, there is.
Okay, did you ever read that narrative?
I did.
Did the narrative mention the living conditions for the children?
At that point, I believe only Madison was residing in the home at that time, but there were appropriate living conditions. There was food in the home. I talked to Mom about her finances over the phone. She was able to apply for food stamps and get additional money to be able to care for all of the children, but it was deemed appropriate by the Wayne County worker.
Okay, so you're saying that it was deemed appropriate for MH to reside with Mom, but was there any reference made for the placement of all the other 4 children with Mom in terms of sleeping arrangements and things like that?
Not at that time. However, prior to and immediately following, within 48 hours, I believe, or so, Wayne County was back in the home confirming that everything was appropriate once the boys had arrived. So the 3 remaining children arrived.
All right, let me ask you this question, ma'am. Is it appropriate for all the children to sleep in one room or no?
No,
Okay. And you're not able to tell us what conditions exist at this point at Ms. Higgins' home. Fair statement?
I did not view the home, fair statement.
Okay. So the children could be at this point sleeping in one room altogether for all you know.
I want
And I want to
offer
I want to
speculation.
restate that too. I do have a foster care background, so I am actually talking from a foster care. And when it's a parental home, there really are no legal parameters regarding how many children can be in a room and of what sexes and genders.
Okay. And are you aware of whether or not Mom influences the children?
I am not aware if Mom influences the children.
All right. But you can't say that does not happen. Fair statement?
Judge, I'm going to object against the
Action,
relevance.
speculation.
I'm not sure how this is relevant to the safety of the placement home.
Well, I think it's very relevant, Judge. There was a prior acrimonious history between the parties, being Mr. Higgins and Mrs. Higgins. And I'm concerned that Mom, Mrs. Higgins, is attempting to adversely influence the children as a payback for what happened in Wayne County when they were in process to terminate her rights.
Your Honor, if I could just respond to my objection to speculation. This is also has nothing to do with the preliminary hearing as far as one of the elements meant for removal from Mr. Higgins. This is a very fair question counsel asked for trial, but not at this level. It's well beyond the scope of what we're doing here today.
I'm gonna sustain the objections. I do think we're pretty far afield of the immediate questions. And secondarily, it certainly assumes quite a few facts that we don't have any evidence of at this point. So if you could move on to your next question, that would be great. Thank you.
All right, Ms. Jones, did you actually read a report prepared by the Lenawee County Child Advocacy Center?
I did not.
And you yourself are not qualified, is it true, to render an opinion based on a forensic evaluation of a minor child with allegations of sexual conduct, right?
I am not qualified to render an opinion
Yes,
based on a child advocacy report.
no,
I'm not
let me restate the question. I apologize if it was unclear. Is it true that you are not qualified to render an opinion of a forensic interview of a minor child in a situation where it's alleged that there's been some sexual abuse?
And I honestly don't know the answer to that question because I don't know what would qualify me to do that. I am trained as a forensic interviewer, so I don't understand what you're particularly asking in that question.
Okay, so let me continue. Trained as forensic, you are trained to perform forensic interviews?
Yes, sir.
Okay. In this type of situation?
Yes, sir.
What are your qualifications?
I have been to forensic interview training. I am a trained forensic interviewer through the state of Michigan.
Okay, let me ask you this. Have you ever done a forensic interview of a minor child in the state of Michigan?
Several.
Are you claiming that you will be the expert in this particular case involving the forensic interview?
I'm not saying I'm going to be the expert. I did not interview the child. All I am saying is that I am trained to forensically interview children.
Okay, so you're trained, but are you certified to do that?
I don't know if there's a certifying process. We go to training, multiple days of training, and we receive a certificate of completion.
Okay, and let me ask you this. This certificate of completion, but let me back up. Were you present at this forensic interview conducted by Janice Stidden?
Yes, I was.
Okay. Are you or are you not going to be rendering an opinion based on that observation?
I'm sure at some point I may be asked. I don't know at this point whether or not I'm going to be rendering an opinion based on that particular forensic interview.
Were you visible to the child during the forensic interview?
No, I was not.
So any mannerisms that might have occurred between the interviewer and the child, you wouldn't have observed that personally, true?
I would have observed that personally. We are behind a two-way glass.
Did you or did you not prepare a report regarding that forensic interview?
I did not prepare a report regarding that forensic interview. I was an observer of that forensic interview.
How many others observed?
2 others.
Whom?
A representative from the prosecuting attorney's office, and also the law enforcement officer that's assigned to this case in Cambridge Township.
Was there any reason why Mr. Higgins wasn't contacted and allowed the opportunity to attend or have some representative from him attend this forensic interview?
A representative from him was allowed to attend. His mother was there.
Okay, so you're telling this court that he was given notice that he could have his representative for purposes of observing this interview, he could have a representative there, a professional person.
No, there are no other observers of the interview other than the department, the responding or corresponding law enforcement agency, and a representative from the prosecuting attorney's office. Parents don't have the ability to have someone sit in on their behalf.
Was Ms. Higgins there?
She did not observe the interview. No, she did not. She had the same capability that his mother had, which was to speak with the staff prior to the interview and offer any input.
Are you aware of whether or not these inputs were documented in writing?
I don't know if the forensic interviewer took notes. I took personal notes, but I don't know if they include that in their report or not.
Do you still have those notes?
I do have those notes.
Okay. Can I ask you to preserve those notes for me, please?
Yes.
Have you distributed those notes to anybody?
No. They're just my personal notes I was jotting down while people were talking.
Was the interview recorded?
Yes, it was.
I have no further questions at this time.
Okay, Ms. Berger, any questions?
No, Your Honor, thank you.
Any other witness presentation or redirect, Mr. Amadeo?
Brief redirect, Your Honor.
Go ahead.
Ms. Jones, is it true that you're the assigned CPS worker on this case?
Yes, I am.
And were you trained in forensic interview techniques?
Yes, I was.
How many forensic interviews do you feel you've witnessed, if you know?
Witnessed? Probably about 15 to 20 witness.
Okay, and of those 15 to 20, how many had a respondent or defendant present or the representative during this interview?
Oh, at the Child Advocacy Center, it would be substantially less than that, but none.
Right. So would it be fair to say it's not normal to have a potential perpetrator watch a forensic interview?
That is correct.
Okay, what's a 154 investigation report?
And the final CPS report,
Okay,
initial service plan.
has that been approved yet by your department?
No, it is not.
Thank you, nothing further.
I have a recross, Your Honor.
Go ahead.
Thank you. What is a 847?
An 847A is the form that we give to parents. It's their notice of placement on the central registry.
And are you the one that created the family team meeting report?
Yes, I am.
Okay. And you've actually accused Mr. Higgins as a perpetrator. Is that true?
Based on the evidence I had before me, yes, we made a finding that it is more likely than not. There's a preponderance of evidence to support that allegation.
Okay. But you're basing that on on a situation where it's hearsay and it's an issue of whether the forensic was conducted properly and not even going into the whether or not mom had a motive to do this. Is that a fair statement?
That is absolutely not a fair statement.
So you've used the word confirmed as a perpetrator. What does that mean?
Just basically what I just talked about. There is a preponderance of evidence to support the allegations of sexual abuse. So based on the investigation, we did find that there is the possibility, or more likely than not, this occurred.
Okay, let's talk about that. You're mixing terms here, and I need to understand what you mean. I'm not trying to get a different answer. I'm just trying to understand you. Are you testifying that there's probable cause or that there's a preponderance of evidence?
Preponderance.
What do you understand preponderance to mean?
Greater than 50%.
And who is the one that made the decision that there was preponderance of evidence greater than 50% that my client was a perpetrator of child abuse and or child neglect?
Myself, along with my supervisor,
Who's your supervisor?
Vanessa Bird,
How do you spell Bird?
BIRD.
What did she do for purposes of this decision, joint decision?
I'm going to object, Your Honor. That'd be a question for Miss Bird, not Miss Jones.
Well, I think it's a perfectly fair question. They collaborated to make this decision and the witness would know what was done.
I'm gonna overrule the objection. She can answer if she can, and if she can, I trust her to tell us.
Judge, I have a separate court matter. I only had an hour reserved for today. I do have a 2 o'clock that I need to connect to as soon as possible. So I was just hoping that we can streamline this so we don't have to come back for the 4th time on a prelim.
Your Honor, I'm streamlining. This is very little that's left. I'm not calling any witnesses, so if we could get a response from the witness, I'm done.
Okay.
Because I respect counsel. She needs to go. I respect that. I don't mean to stop anybody from attending a hearing. So I apologize, but if she could just answer that question, then I'm done with my, unless the other counsel has a redirect, but I don't know if he does or he doesn't, but.
So I meet with Ms. Bird weekly and we talk about the information that I've obtained during the course of the investigation, and she has read all of my contacts regarding anything that I've done throughout the course of the investigation.
Okay, that's it.
Any recross, Ms. Berger?
Nothing further, Your Honor. Thank you.
Thank you. Any other witnesses, Mr. Amadeo?
No, thank you, Your Honor.
Okay. Mr. Lizahu, do you want to confirm you don't have any witnesses for us today?
Yes, Your Honor, I confirm that.
Ms. Berger?
I have none, Your Honor.
All right, would you like to, well, we'll have you give your report and recommendations if you don't mind after any closing comments by the other attorneys. Mr. Amadeo?
Thank you, Your Honor. Given the testimony of the worker, there's probable cause to believe at least one of the allegations contained in the petition are true, as the investigator made significant efforts to verify these allegations contained in the petition. There's a risk of harm to MH. There's a child living in fear, and there's potentially a companion criminal case. Simply put, we ask you authorize petition, take jurisdiction over the child, pending and set a pending trial for the respondent parent. Thank you.
Comments, Mr. Lizahu?
Yeah, Your Honor, my client denies any and all allegations of impropriety. There's no objective evidence to substantiate the allegations. Aside from a child who we believe was wrongly influenced by mom, that we believe this is a complete fabrication. I'm hoping I understand what the courts needs to do as far as the children are concerned, but I also want the court to weigh what's out there. I don't believe these allegations are supported by any evidence. As far as the forensic interview is concerned, Judge, we never got the report. And we don't know if it was done properly or not, or we haven't even gotten any evidence. So I'm asking the court to deny the petition.
Okay, Ms. Berger.
Yes, thank you, Your Honor. I have been able to conduct a virtual home visit with the children in mother's home. As stated, she does reside in Wayne County. I do plan to visit them in person for this before the next hearing, or at least the next reporting period. But the children all report to be some stage of angry or confused and upset with their father. I think that it would be best if they all immediately be enrolled in counseling. The older child is open to that, is willing. So I would make a recommendation that he immediately be enrolled in counseling to address any issues. I know that the minor daughter has been forensically interviewed, as we've stated on the record. I would ask that the family and the department follow all recommendations of that interview, get her enrolled in counseling, possibly have a trauma assessment conducted. And I think counseling for the other two of the triplet set would be appropriate as well. For now, they all state that they want to reside with their mother. So I think at this point, she is an appropriate placement. She's been open and honest about her past CPS history and about the sort of immediate difficulties that she had with going from not having the children all the time to having all of them all the time. But they seem to be adjusting okay. It's fairly new in this situation for them. But I have been able to review all the pleadings. I've been able to review other documents provided to me from the department, from the parties, from mom, other orders from different courts. And at this time, I do believe it's in the best interest of the children that we proceed on this petition. Thank you.
Thank you. Well, the court does find that there has been a showing of probable cause that one or more of the allegations in the petition are true and would fall within MCL 712A.2b, specifically those allegations of sexual abuse against the child, which appear to be at least preliminarily vetted through CAC interview, wherein the child confirmed the same. That, in addition to the element of criminality associated with that, certainly do present a risk of harm associated with any contact at this point between these children and their father, recognizing that there is a bond between the children and their father, and that it's appropriate in such circumstances to order an assessment. The court is going to direct that all 4 children have counseling to determine the appropriateness and conditions of parenting time. So we'll need an evaluation, and specifically within that, we need to know whether or not there is a risk of harm associated with allowing parenting time between each of these children individually and their father. The court finds all interested parties were given notice for purposes of today's, the conclusion of today's preliminary hearing. We've certainly had plenty of time for all of the parties to appraise themselves of what the allegations are. We confirmed that all parties now have copies of that, and that we have a Wayne County case as well. And I have received and reviewed the custody order, which is obviously very relevant for purposes of where the children will be placed moving forward. The request for a jury trial, that written request for jury trial must be made within 14 days in order to secure that. In the meantime, the court is, in addition to the authorizing of the filing of the petition, confirming that, I'm releasing this child, all the children, to the non-respondent parent mother in this case, Ms. Leanne Higgins, pending further proceedings. There will be terms and conditions necessary to protect the physical and mental well-being of the children, also contained within today's order, which are, of course, the suspension of parenting time pending the counseling assessment on parenting time. Ms. Higgins will have to continue to make herself and her home obviously available to the department. We have heard some of, and I am familiar with some of the allegations that gave rise to prior contacts between this parent as well and the department. So we'll look for any referrals to be made from mom. Would be great, Ms. Jones, in any outstanding areas that she may need help support with. I will ask also that the department or the agency or whoever's assigned moving forward refer the children for counseling, individual counseling as well, within 14 days. I'd like to see a copy of the initial 30-day trauma screenings for each child. I have outlined these things in the last page of the order as well, although I appreciate you taking notes. I can see that happening. It's great. If any child is indicated for a trauma assessment, I would also expect that you don't wait for me for that referral. It's clear based on the testimony and the petition being confirmed that it does not apply to the particular case. So at this juncture, we will look at pretrial as well as trial dates. Assuming we get that written request for jury trial, I have available, the earliest available dates I have would be in November. If you could look at your calendars, please. I'm assuming this would be a 2-day trial. Correct me if I'm wrong, gentlemen, unless you think we would need more time than that.
I think 2 days is fine, Judge.
I don't know if it would be or would not, Judge. I don't have the materials, and we're dealing with forensic. Could be a long thing. So I do have a trial already scheduled, jury trial scheduled November 13th, 14th, and 15th. And some other things. So I'd suggest 3 days, Judge, just to be safe.
The earliest I can give you 3 days would be November 27th, 28th, and 29th. Or 29th, 30th of that week. So I could go Wednesday, Thursday, Friday of that week also, if that works better.
I apologize, Judge, but I'm in a major trial November 28th for a week.
All right, let's go out to I have the week of December 18th. I feel like 3 days in there somewhere.
I'm wide open that week, Judge.
Just check in.
My suggestion would be Wednesday, the 20th through Friday, the 22nd.
Judge, I'm sorry, I'm out the 15th until the 4th.
Well, the children are placed with a non-respondent parent, so that does give us a little bit of time for purposes of our jury trial. We have the week of January 8th.
Wide open, Judge.
That will work, Your Honor.
Would you want the 8th, the 9th, and the 10th, Your Honor?
Yes, does that work for everyone if we schedule 8, 9, and 10 of January?
Yes.
Starting every day at 9.
I'll make it work, Judge. I have some other things, but I should be able to get coverage for those.
Okay, thank you, Ms. Berger.
Your Honor, can I make a comment, please?
Okay, what would you like to say?
I look forward to William Amadeo's offer to personally deliver the discovery materials to my office, and I will invite him for a cup of coffee.
All right, on that particular subject, it's been the court's experience that a CAC interview has to be secured using a particular order from this court. So I'm not sure how that interferes with coffee hour, but I look forward to reviewing such an order to make sure that everyone has what they need to prepare for trial.
We'll stipulate a protective order for your review, Your Honor.
Thank you so much. All right, so we're scheduling jury trial the 8th, 9th, and 10th of January, commencing 9 o'clock each day. For purposes of pretrial, I have as early as October 23rd at 2:30.
I'm available then.
I have a 2-week trial, Your Honor, that should end right before that, but if for some reason it goes longer, I will have some, Lestage and Thomas will cover and be prepared for it, so we'll make that date work.
Berger?
Works for me, Judge.
We have a miracle, a tiny miracle. October 23rd at 2:30 will be our pre-trial. We'll look for all of that. So, I mean, we might as well plan on looking at a little review report for all of the issues that we've identified today, hoping to look at those moving forward. I'd love to hear how the family's doing in the meantime as well. Let's call it a pre-trial review on October 23rd at 2:30 p.m. Unless there's any questions, I believe that's all for today.
Thank you, Judge. Take care.